I'm Councillor Janet Evans, and I'll be chairing this meeting. The committee for this hearing comprises Councillor Lucy Knight and Councillor Toby Benton and me. We are joined by David Williams from the Council's licensing team. Our legal advisor is Heidi Titcomb, and she will be accompanied by Georgia, I'm going to say it properly, Hoideboek. How's my Dutch? Also with us is our committee officers, Holly Weaver and Nima Muhudin and Jerome Treherne. Before we start the hearing for this case, there are a couple of ground rules. Please keep your microphones on mute until you are invited to speak. It's only 2 microphones can be used at any one time. And please make sure your mobile phone is off. Thank you. The case before us today is to grant a license for the Royal Hospital, Chelsea, London SW3. Now for declarations of interest. I confirm that I have no declaration of interest to make regarding this item. Do the other members have any declarations to make? Councillor Knight? No. Okay. Councillor Benton?
No, Chair.
Thank you, colleagues.
None.
For clarity, I'll outline the procedure, which has already been circulated with the papers. First, the licensing officer, Mr. Williams, will give a brief outline of the application. Please, could you confirm your attendance?
I'm here, Chair.
Thank you. Then I will ask the applicant, Lieutenant Colonel Nicholas Mott, where are you? Thank you, to present the applicant's submission. I understand he is joined by Mrs. Jo Cochran. They will have up to a maximum of 10 minutes to do so. The committee members and our legal advisor will then ask questions of the applicant. We will then allow the objectors who have filed a valid objection to ask questions of the applicant for a maximum of 5 minutes each. Secondly, it will be the objector's turn to present their submissions. They will each have 10 minutes each. I have an attendance list which shows 6 objectors would like to speak, namely Sharon McMillan and Alim McMillan.
They're here, Chair. My name's Alan Thomas. I'll speak on their behalf.
Okay. Gisela Gledhill, Catherine Manning. Okay. Paul Lever, representing the Chelsea Society. Thank you. Michelle Van Tulder. Thank you. Governance, can you please confirm all the objectors are here?
Yes, thank you, Madam Chairman. We do have another registered speaker who's attending today, Mr. Leo Russell. I don't know if you intend on speaking for the application? No, thank you. That's everyone then, Chair.
The committee will then ask questions of the objectors, followed by the applicant if he wishes to do so. After this, we'll ask our legal advisor, Heidi Titcomb, to deal with any questions she may have, for example, regarding any conditions. We'll discuss them with you. There will be no summing up, and the meeting will end. I would like to remind everyone that the committee has read the papers which comprise the main pack that has been circulated to the parties, so there is no need to repeat their content, please. But please do draw our attention to certain points and pages. So let's get going. Mr. Williams, please can you outline the case for us and advise if there's been any additional documentation received?
Thank you, Chair. Good morning, everyone. Today's application has been submitted by Royal Hospital Chelsea Appeal Limited for the grant of a new premises licence in respect of the Royal Hospital Chelsea, Royal Hospital Road, London SW3 4SR. The premises currently benefits from 2 premises licences, and the applicant is seeking the grant of a new premises licence to consolidate both these licences into one. For simplicity, I'd refer you to the table shown on pages 6, 7 and 8 of the main bundle for current and requested hours and licensable activities. The main differences being the addition of late night refreshment for 1 hour, additional hours for off sales, and additional operating hours, which we do not licence, for the Soane Stable Yard Cafe and Soane Stable Yard Inner Court. It is my understanding that the licensable activity of boxing or wrestling originally applied for has been withdrawn by the applicant. The licensing authority has received 48 representations objecting to the application, 4 from local residents' associations, including St Leonard's Tenants Association, Christchurch Area Residents Association, Smith and Woodfall Residents Association, and Chelsea Society. A summary of these representations can be found on pages 13 to 16 of the main bundle, and a copy of the full representations can be found at Appendix D. The licensing authority has also received 1 representation from a resident supporting the application, with a summary on page 16 of the main bundle, and the full representation can be found at Appendix E. Council records show that at the time this report was written, no noise complaints have been received in the preceding 24 months. No temporary event notices have been submitted in the past 12 months, and the Planning Department has not made a formal representation in connection with this application. Other than the list of proposed conditions that are to be considered if the committee were minded to grant the application, there have been 3 sets of additional documents circulated for this hearing. On the 21st of June, a witness statement of Alistair Macmillan and exhibits. On the 20th of June, applicants confirming that boxing is to be removed from the scope of this application and that the boxing condition is to be carried over. And on the 24th of June, existing versus proposed conditions. This follows discussions between Mr Thomas and the applicant. That concludes the summary of today's application.
Thank you, Mr. Williams. Now for the applicant's case. Lieutenant Colonel Nicholas Mott, can you please outline your case and explain whether there have been any amendments to your application? Now, before you start, I would like to say one thing. We are going to put the layout up on the screen because we're totally confused. So I'd like you to, governance, can you put that up? Is it up here? Nope. Okay, that would be really helpful, I think, for everybody.
Chair, was there a particular plan you wanted? I think there's about eight pages.
Well, I think I would like the Lieutenant Colonel to please say where he's applying for, and we'll put that up. I think it would work very well, because quite frankly, we don't know why you've applied for this, because you have all of these permissions, and we've taken away, you've agreed to take away wrestling and boxing. So maybe it could provide clarification for the objectors as well as for the committee. That would be great. Thank you. Please put your mic on.
Good morning, councillors. Good morning, ladies and gentlemen. Nicky Mott, I'm the Director of Estates and Facilities and also the Designated Premises Supervisor of the Royal Hospital Chelsea. And I have with me Mr Joe Cochran, who's the Head of Events, who can give any more detail to some of the protocols that we have in place across all of our venue spaces. rather than going into the drawings at the moment, Councillor, if I can go through the notes, and hopefully that'll bring everything to light for you and,
Okay.
and for the residents. You know, to explain the reason and the intent of the application, first of all, it was to surrender the current souvenir and gift shop licence on the movement of the post office from the 3rd of September, which is going to be part of the new Soane Stable Block Exhibition Centre. After consultation with the RBKC licensing team and pre-application advice, it was advised to incorporate both the gift and souvenir site and the on-licence into one licence, which is going to be better for governance and easier for management on the ground by bringing those two licences into one. It was also an opportunity to update the conditions to reflect today's operational requirements and not as they were written in 2005, apologies. It was also to accommodate the Soane Stableyard Visitor Centre, which will be incorporating a visitor experience, museum, post office for the local community and cafe for the local community by day, and venue space with restricted conditions for using during the evening. Initially, it was to also accommodate the military boxing on 1 day per year by utilising the stands in Founders Day, but since the concerns that's been raised, we removed that part of the application. Previous consultation around the Soane Stableyard and these licences applications started in November 2023 with a meeting with myself, the Governor and a small group of resident chairs for us to start to explain the upcoming event season, the outreach programme, the use of Ranelagh Gardens and the Soane Stableyard, and for that to be then communicated with ongoing plans across the wider community. In January, I then had a meeting on site with a number of members of the licensing team to discuss licensing options for the Royal Hospital, and then got pre-application advice provided by the RBKC. In February, we had an open consultation evening to discuss events, Soane Stableyard and licensing application in Wrenhouse with local residents, RBKC authorities, ward councillors and police in attendance. In April, the Royal Hospital Communications team, via dot mailer, highlighting and giving further information around the Soane Stableyard and the licensing application. But I do appreciate at that time there was no mention to the residents of the boxing. Late April, we submitted the application, which naturally was advertised for up to 28 days. During that 28-day advertisement, the Royal Hospital did receive further communications with some of the local residents regarding the application, and although the comments were sound and fully acknowledged, the Royal Hospital was advised to signpost all such objections directly to the licensing team and wait for the 28-day period to commence before then looking at the representations. Most recent consultation, after the hospital was taken back by the number of local residents who had raised concern, naturally we withdrew the application for the boxing as a licensable activity. But as I say, for clarity, Chair, that was very much for us to just utilise the stands on the main site after Founders Day, and part of the military ethos was to then invite 2 regiments to come in and potentially do a charity event. But as I say, that part of the application has been removed. After further consultation with legal teams representing one of the objectors, much common ground was achieved to change and amend a number of conditions to better suit and reassure all parties concerned. And the revised conditions, as mentioned, were submitted on Monday the 24th of June. Based on some of the concerns raised also, particularly around the late night events, the Royal Hospital has since, as part of the looking at the conditions, has removed the non-standard timings which was extended till 0100 hours in the previous licence, which is a carryover from the previous licence. We've removed the 0100 hours non-standard timings, and it's really, most importantly for the hospital, to have the 0800 hours to the 1000 hours, so we can accommodate breakfasts during the major events and any recorded music during the the Global Champions Tour, which usually kicks in at about 9 o'clock in the morning. So that's more important for the hospital. We can live with removing the 0-100 hours, which was causing concern. The Royal Hospital really doesn't believe, in line with the amended conditions of the licence application, that it puts any increased risk or reduces the Royal Hospital's commitment to promoting the licensing objectives. And if I may, if I can just touch on a few of the things that we actually have in place, which, like I say, Mrs. Cochran can go into more detail with our on-site protocols on top of the conditions. In prevention of the crime and disorder, we have a 24-hour on-site site security. We're having an uplift which has already been granted to the security during the daytime for the Soane Stable Yard activities, the museum space, from August. All events across the hospital, including sporting events in Burton Court, has dedicated management or security visible and present throughout. CCTV has been installed covering all main entrance points across the hospital from 3 years ago, and all security staff are SIA qualified. In prevention of public nuisance, the events management plans in place for all major events are shared with emergency services. Royal Hospital Chelsea protocols will include signage to be placed at exits when guests are leaving the site to be respectful, with directional arrows to be displayed directing the guests away from going through the built-up areas and keeping to the main roads as they exit the Royal Hospital Chelsea. The client briefings and Royal Hospital management throughout all events is mandatory. Additional and rewording of listed conditions to reduce and manage noise and nuisance to neighbours has been implemented. Restrictions on when and where outside events can take place within the Royal Hospital, and with strict timings, as it's done for many years, which are to be strictly enforced, is always in place and managed by the events team. Management of exits and variation of them with so many gates at the Royal Hospital Chelsea allows us to ensure dispersal of guests move as far away from local residents. The protection of children. The Royal Hospital has a safeguarding policy committee in place. The events team and the Burton's Court senior management team are part of that committee. Hirers are briefed and made clear of their responsibility with regards under 18s attending any form of events. And they're obviously naturally to be accommodated, with an adult throughout. The new condition, one of the new proposed conditions, is to introduce the under 25 challenge as part of the application. Strict policies within the Royal Hospital Chelsea residents. For the residents, we have 48 residents living on site with children, have to adhere to that safeguarding policy. We have an Army Cadet unit that operates on a Monday evening at the Royal Hospital Chelsea, which now has up to 40 children attending on a Monday evening. And again, it adheres to that safeguarding policy, the child safeguarding policy. To achieve public safety, all major events and safety advisory groups, and have done for the past 3 years, attended the safety advisory groups with RBKC. All plans, event management plans for those major events are scrutinised in detail. All hirers and suppliers support risk assessments and method statements regardless of the scale of event. Events management and security are all first aid at work trained and present at all events. The annual health and safety audits and fire risk assessments are always implemented across all venue spaces, and then resources allocated accordingly to repair or replace. External caterers must be registered with the local authority. Approved suppliers must operate within listed conditions of the premises licence, and they sign the declaration and submit it to me as the designated premises supervisor when operating on site. Strict adherence to the fire strategy and the implemented numbers is carefully monitored. To summarise, the Royal Hospital sees itself as a considerate neighbour, and we underestimated the concerns that was going to be raised around the boxing. But as I say, Chair, the intent was for potentially one boxing event every couple of years by utilising the stands, which costs the hospital a serious amount of money to put the stands up, and it was an opportunity for us to have a charity event for the two regiments and for the Royal Hospital to generate a little bit of income. But as I say, that has been removed. The safety and the intrusiveness of the pensioner community is always the first priority for the Royal Hospital Chelsea before any events take place. And as I say, I have 48 families, which totals about 100 people living on the site, so we do not put anything that's too intrusive to the pensioner community and the living community before we even go outside of the gates. That's always the first and foremost. And anything we're doing there, naturally then, has the benefits for the local community. The Royal Hospital does nothing without sharing its intentions and its plans with the ward councillors on a regular basis. The Royal Hospital has put in place an annual, which we started this February, a briefing with the local residents to update on the event season, the upcoming event season. No noise or nuisance complaints have been raised in the past 24 months, and no representations have been made from the emergency services. Just to finish off, Chair, if I may, as the designated premises supervisor for the Royal Hospital Chelsea, we absolutely go out of our way to ensure that the objectives of the licensing is met at all, in all cases. I have nothing else to say, Chair.
Thank you very much. We'll now have any questions from the committee. Councillor Knight?
Hi, thank you. I was just going to ask, for the events that you plan to hold under this new licence, in comparison to the past and the future, are they the same type of events, or could you just talk to us a bit more about what these would be, so we can, the residents can understand and maybe feel a bit more assured?
Yeah, absolutely, Councillor. There is no planned changes to anything that we've done over the last 10 to 15 years on the main site, and in particular in Burton's Court. The only changes as part of this licence is for us to incorporate the Soane Stable Yard and the new development within the Soane Stable Yard. By day, it's very much going to be for outreach, for the local community engagement. It'll have a cafe open to the general public. We're opening one of the side gates of Chelsea Gate, so you don't even need to go via the security. It'll have the post office in there open to the community. And that's by day. There will be some activities plans where we're engaging with the local community as well, and we've got an activities team that's doing that by day. By night, from 5 o'clock onwards, that will operate from 8 till 5 o'clock, and we've got an approved caterer now, Heidi Bakery, that will be taking on the catering facilities within the cafe. By night, the head of events and the events team, up to no more than 50 events per year. The types of events, which I think we need to spell out, is when we're saying up to 50, 5 of those would be around the Chelsea Flower Show. 5 of them would be around the Chelsea History Festival. About 14 would be around Christmas, with some form of Christmas fair, trinkets and that sort of stuff during the day. And then the other events that would fill in the gaps to raise some income for the hospital would be around meetings, corporate meetings, potentially by day or by night. It would have potentially 1 or 2 civil ceremonies per year. It would have corporate or commercial events that come in. And again, nothing would be outside of the building beyond 2200 hours. So that would all either be contained within or in the courtyard. We would anticipate that the vast majority of those events I've just mentioned would be no more than 40 or 50 individuals. Potentially 2 times a year, 3 times a year, it may well go up to the numbers of the fire strategy contained within a marquee in the courtyard, which would take the numbers then up to the 150. But we really won't know how positive that will be and what the uptake will be until we open the Soane Stable Yard. But to reassure the residents, that would certainly not be our first port of call for the larger numbers, because we have the Great Hall, and we have the State Apartment, and we have the Wren House, and we have the South Grounds, which is even further away from the residents to reduce that impact. The exiting from the Soane Stable Yard for any of those events will not be via Chelsea Gate, which is immediately into the resident location. It'll go via the north front, out of Chapel Gate, with directional signs asking the guests to be respectful and to move down the Royal Hospital Road.
Thank you. And one of the things I was going to ask was there's a sort of variation in the number of events in the documents. One saying 50 and one saying 30, but I assume from what you're saying now, you're sort of envisioning 50 per year. And then that's correct.
Yes, up to 50, including all of those variations, Councillor.
And then the other thing I was going to ask was, when you say corporate events, have you been doing events like that in the past?
Yes, yeah, absolutely.
Okay, and there haven't been, and you say there's been no complaints in the last 24 months, but previously, beyond those 24 months, have you experienced any?
Not in my tenure, Councillor, but Joe, you've been here longer.
No, I've been at the hospital for 12 years. We've never had a complaint about a corporate event. It tends to be a drinks reception for 2 hours, usually leaving by 9:30. Fairly small events generally, and very manageable, similar to the charity events that we have.
Okay, thank you.
Councillor Benton.
Thank you, Chair. Thank you. So I think part of our job is to, in this sort of a hearing, is to, especially when we're listening to objectors, is to think about what the worst case scenario could be, right, as the license that is being proposed. What, you know, and if we can put everyone's sort of fears or worst fears to rest to whatever degree we can. So in that spirit, I'd like to ask, what do you imagine the most disruptive event that you are that could feasibly come about under this license? And I mean, you have actually answered a little bit of my question about dispersal, which I understand is pretty robust. But if you could just humour me and answer that, how would you see that happening?
Yes, Councillor. I think the two most intrusive events, which we work closely with RBKC and the event organisers, is without a shadow of a doubt is the flower show, because of the numbers that come in. But we're constantly learning and trying to put things at ease on that. And as I said in my opening comments, we've put in place now, after talking with the local residents, that we want an annual catch-up in the February, so we ensure that we capture those comments and those concerns around that, so we can feed them into the system with those event organisers. And then I think the other one, which gives large numbers, would be Live at Chelsea. Now, we haven't had Live at Chelsea, which is a series of concerts. We have 4 concerts immediately after the Founders' Day. And again, the reasoning for that, it was put in by my predecessor, the reasoning for it is to offset the costs of Founders' Day, which is the annual event for the hospital, which absorbs a lot of resources, you could imagine. And we have Live at Chelsea, and what we've done, it hasn't been there for the last 2 years, but we've changed the scope of those concerts, and we've spoken to the organiser, Kilimanjaro, and we don't want the normal pop groups any longer. We want a classical opera theatre style, and they're actively working on that to try to bring that sort of concert into the Royal Hospital, which will hopefully change the audience naturally, which will be a little bit more easier on the grounds. But other than that, there's nothing at all, Councillor, that springs to mind of concern.
Okay, thank you.
Yeah, I've got a few questions. I would like to know the type of events. Are you having weddings? Does the antiques show fall under your authority?
Yeah, so we've got the Treasure House Fair showing as we speak now. I was there last night on their opening evening. That's on the South Grounds. the Treasure House Fair, which replaced Masterpiece. That is one of the 4 major events. The 4 major events on the South Grounds from April through to August is Salon Privé, which is the luxury car show. That rolls into the flower show. That rolls into the Treasure House Fair, and that rolls into the Global Champions Tour, which is obviously the horse event. Weddings.
So we do have weddings. Last year we had 7 weddings, so it's never huge numbers, and that's across all of our spaces. We would hope to get a couple more in the Soane Stable Yard, but that would primarily be the civil ceremony and maybe a small dinner or lunch, and then them moving off-site. The weddings generally tend to be numbers of about 60 to 100, all off-site by midnight, and every client that has an event with us within their contract has to sign our very detailed protocols document, as do every supplier we work with. So we have a strict approved list, so everyone knows our terms and conditions, how they work within the space, and they agree to that within their venue hire.
Thank you. Now, several people have expressed concerns about noise, so could you just talk us through, if you have a wedding, let's say, what is the noise limitation?
So we have, in the protocols, the decibel limit is 80 decibels, which is in line with other venues across London. We spoke with Chelsea Physics Garden as well and compared how they manage their noise levels. We have an event manager throughout any event who would frequently check that noise level from the figure court to make sure it's 80 decibels from that point, not inside the venue. And then we would do walks around the site during the event to make sure it's not too loud. If at any point we think it is, we will go and speak to the musicians, the band or the DJ and make sure they turn it down. But we make it clear from the beginning of the event that that's the limit, and we will turn the music off if they don't adhere to our policy.
Councillor, if I can just add to that, it just brings me back to the point I said that all of our venue spaces are in close proximity of the accommodation of our 300 Chelsea pensioners and those 48 residents. So this is why we monitor with inside the Y before it even gets to the railings to ensure that those decibels, those limitations are met before the noise even starts to go wider into the community.
Thank you. And you mentioned that you had several meetings with the residents. Can you please elaborate?
Yes, Councillor. So we had a meeting with a small number in November to start with the Governor and 3 of the resident chairs to start highlighting. It was predominantly around events and the Soane Stable Yard and the outreach programme at that meeting, just to reassure people what was going on at the hospital. And we took a lot from that because there was concern that Ranelagh Gardens was going to be closed, and we've come up with a policy to ensure that the old age people in the local community can still use Ranelagh Gardens even when we open the Soane Stable Yard. We then had, like I said, I then had meetings with RBKC and took advice from the licensing team and done the pre-application. And then we went out and circulated with the full list of resident chairs and the ward councillors and the emergency services, and we hosted an open consultation evening late February in Wren House, where we went through the event season. We went into more about the licence application and reassured people at that stage that we wasn't changing anything in Burton's Court. And it was predominantly to incorporate the Soane Stable Yard, and we took questions from that meeting. And then after that, our public engagement team then circulated again a brief at the back end of March, early April, highlighting the Soane Stable Yard, what's going in the Soane Stable Yard, touching on the licenses and what we were trying to do to bring 2 into 1 to simplify things that have been in place since 2005. So that's what we've done with the residents' chair.
And the residents, did they show up? The Chelsea Society, did they show up? And did the other residents' associations show up to these meetings?
Quite a few, but I couldn't name them all off the top of my head at the moment. I know that there's some of the resident chairs with us today who was there during that evening as well. You know, so we had a good number, and you know, we had ward councillors present, we had police present, we had the governor present, and we'd done a series of presentations, and you know, and I presented during that, you know, during that event as well.
Thank you very much. Now we'll have questions from our legal advisor.
Thank you, Chair. I just wondered if you could just help me with a few things. If we can put that plan up on the screen again. Just wait one moment whilst it's coming up. I think this is from page 69 of the committee papers. '69. Looks like that. That's it. Thank you. Can you just clarify for me where the visitor centre is, because it's not, it doesn't seem to be appearing on the plans anywhere, but there's reference to a condition of the visitor centre.
Yeah, certainly. It's contained within the Soane Stable Yard. It's on the western elevation of the buildings, directly next to the Army Museum. So it's an exhibition centre museum which naturally rolls into the new gift shop and post office. So it's on the western elevation of the Soane Stable Yard.
So is it at the bottom? On that plan, is it on the, on that plan, it's sort of west,
Just
it's
where the,
near
where the
Burton's
cursor
Court. Is that
Yes,
correct?
yes, it's in there.
So it's actually in Soane Stable
It's
Yard?
inside Soane Stable Yard. So, so just for clarity, inside Soane Stable Yard, you've got a commercial kitchen, you've got a cafe, you've then got the exhibition centre, and then we're moving the post office and the shop from the eastern side of the site, hence the reason why we need to surrender that licence in September, and then it makes it more amenable for the local community to be able to go to the post office via Chelsea Gate, which will be unrestricted and straight in, and the post office will be contained in there as well.
Okay, that's helpful. So the hours for that area, what's the terminal hours for that area?
So, sorry?
What are the terminal hours?
So for the cafe and for the exhibition centre, it'll be from 0800 hours to 1700 hours on a daily basis. And then, as I say, up to the 50 times throughout the year, the remainder of part of the site will operate underneath the premises licence timings, which is from up until 2400 hours, but the conditions will restrict anything within the inner courtyard because of the noise and because of the concern, and those individuals that then have to go inside the building. No different to what we do on the rest of the site with the Great Hall, the State Apartments and Wren House.
Well, I'm a bit confused because whilst you do, if you look at your premises licence, your souvenir shop on page 35,
The existing licence?
Yeah, on page 35 of the committee papers. Just find that page.
Yeah.
See, your alcohol off sales starts at 9 o'clock.
Yeah.
But unfortunately, on the application, you've only applied from 10 o'clock.
Yes.
So you're wanting a start time from 10 o'clock, but you've just said to me that you're at the cafe and another area will open from 8 o'clock.
Yeah, so the cafe opens to 0800 hours in the morning, and you know the cafe will stop at 1700 hours, and that's in line with the exhibition centre and the shop, which has also got the off sales within the shop.
Will it be selling off sales from 8 o'clock in the morning?
No, we don't see that. We really wouldn't see, you know, individuals coming in that early in the morning on the tours. So
the reason I'm I'm trying to clarify this, is because on the application, you're asking for on and off sales
Yes.
from 10 o'clock in the morning for your entire
Yes,
site.
yes.
Which would include this.
It includes that,
It
yes.
includes the cafe.
Yes.
And includes the exhibition.
Yeah, if I can explain the reason why we've applied for the off sales across the wider site.
Yeah.
In the existing licence, it's just for the shop.
Yeah.
And on an annual basis, the Royal Hospital, at its cost, has to apply for a temporary events notice for us to put up our shop into those major events. So in those 4 major events, the flower show in particular, and the Global Champions Tour, the Royal Hospital takes a pop-up shop from the gift shop down into the grounds as part of the lease, and then we always have to apply for a temporary events notice to do the off-sales piece, for us to be able to do the off-sales piece on the grounds. That is the only reason we require the off-licence. It's for nowhere else on the ground. It's to allow us, as part of the Soane stable yard, which is having a cart, an old-fashioned cart, that when we have events like the flower show or the Global Champions Tour or the Friends or the Governor's Review, it allows us to put produce on the cart, including the alcohol, to the event, and then sell it in sealed containers in a bag to take it off-site.
Yeah.
So apologies if we've got the timing slightly
No,
wrong.
no, I'm just trying to make sure that we're all on the same
Yeah.
page, because I have to make sure that if the committee's minded to grant a licence, we need to make sure it's the correct hours. So I thought you said you weren't seeking the 30 days non-standard timings, but you are seeking that.
We are
Yeah.
for 8 in the morning till 10 o'clock in the morning, because that supports the major events which start operating at those times. So the flower show may well have a corporate breakfast at 8 o'clock in the morning, and just to make sure that if there's alcohol served as part of that breakfast, a glass of champagne, it's covered. The Global Champions Tour has recorded music in the South Grounds for the first trial rounds at 8 o'clock in the morning. So that part is staying in the licence. The part that the hospital, which is causing most concern, is the variation, or this non-standard variation from midnight until 1 in the morning. The Royal Hospital is quite happy to remove that, which has been an existing condition in the previous licence, but we can operate up to midnight and remove that risk for the local community.
Yeah, so if I can just refer you to page 55. So on page 55, on J, it's saying that you want the alcohol from 7:30. Are you cutting that back to 8 a.m. in the morning? I just want to make sure...
8 a.m.
It's 8 a.m.
8 a.m.
8 a.m.
8 till 10.
Right, and similarly, for your, you've got non-standard timings in late night refreshment, well, you don't need those in the morning, you would in the evening. So for the late night refreshment,
Yeah.
there is going to be no need for 30 non-standard timings, is there? Because late night refreshment only
Yeah.
starts at 11 o'clock
Absolutely.
at night. So you've actually removed, in
So-
I, you've
yeah.
removed those non-standard timings.
Yeah, so when we done the work recently, which was submitted on Monday with the new conditions,
Yeah.
that was taken into account.
Right, so I can remove that.
Yes, you can remove that. And the reasoning why we've asked for the late night refreshments, it was advised to us as part of the consultation with RBKC
Yeah.
that it's a good thing to do for the events team to be
Yeah.
able to offer the clients before they go out, look, have a cup of coffee from 11:30, just calm yourselves down and then move out.
Yeah,
move out.
so if you go to F, section F on page 52, again, you're removing the midnight, but you're keeping in the earlier times.
Yes.
Right, okay. And the same applies to live music. And also, I think that's
So the
all.
recorded music, yeah, we're losing the non-standard times from midnight to 0,
Yeah,
100
got that.
hours throughout.
Okay, that's helpful. And is it your intention that if the committee are minded to grant this licence, which will cover your whole site, that you're going to then surrender both licences?
Yes.
And would you accept a condition to that effect, that it won't come in, that this licence, if granted, won't come into effect until you actually surrender them?
Yeah, so on the application that was submitted, you know, we put in for this licence to be on the 1st of August, and we put the surrender of the post office, because we're tied to the post office, is on the 3rd of September. That's linked into the post office when they physically move the post office. So we can't surrender that until the 3rd of September. And then the 3rd of September is when the Soane Stable Yard goes operational to the general public, because the post office is physically moved across.
So that's the other licence, that's the second one?
That's the second licence.
So you're saying that you couldn't agree to a condition that this licence will come into effect when you've surrendered the second one, because there'd be a gap?
Yes.
Yeah, understood. Okay. And just to be clear, I had circulated some amendments to the conditions, just so I make sure we're all singing from the same hymn sheet. But can you just, on the terms of the conditions of the existing licence, if we go to page, let me find it. Trying to find the best page for you. Yeah, so page 28, this is the conditions of your existing licence for the main site. No, because I'm just clarifying. Yeah. So you've got condition 31, you're not offering that one, are you? About the flower show?
No.
That's gone?
That's gone.
Yeah, okay. And the other one is on the souvenir shop. I just want to make sure we're clear what the application is. So that's page 38. Condition 4, is that still applicable?
No, it's not applicable because it's covered in the main licence.
Covered in the main licence. Okay.
And like I say, the amended conditions were submitted on Monday the 24th.
Yeah, no, I understand. And in terms of the 50 events, what's the timing on the 50 events?
Well, set-up would more than likely start mid-afternoon, late afternoon, as the cafe and the visitor centre is closing down.
I mean, generally. So if you were having a licence, you would have to say when it would start and when it would end. So your 50 events, so like your 30, you've said they start at 8 in the morning and go till 10. And you had said from midnight till 1. So is there a timing that one should put on the 50 events or not? You might say no.
No. No, because there's a complete variation. As long as it's within those licensable hours, you know, from 10 till midnight, all the events will be captured within that time bracket.
Understood. Right, they're all the questions I had. Thank you.
Before the objectors make their case, do the objectors have any questions of the applicant?
Chair, I have just two.
Okay, are they questions? Because I plan to call on it a 5-minute.
They're questions, Chair.
Okay.
I didn't quite catch the reason for the non or delayed surrender of the existing licences. Could Colonel Mott just repeat that for my benefit, please? Why can't the two licences be surrendered prior to this licence taking effect? I thought there was a reason why they couldn't.
He did answer that.
Yeah, I was just
Do you
asking
want him
to...
to go to mention it again?
Would you mind, just
Yeah,
for
yeah,
my
it's-
clarification?
Yeah, it's linked in with the post office and the movement of the post office, which is one of the licenses. And the post office physically can't move until the 3rd of September because it's the movement of the safe and everything else through the post office. So that moves on the 3rd of September, which comes across. Whereas the other license, we put in for the existing license to, to finish on the 1st of August. And we were hoping for for this to less the souvenir shop to come in on the 1st of August, but it's obvious that that can't be the case. So what we would be asking is to continue with the existing license until the 3rd of September, and then the new license becomes live on the 3rd of September.
I think that would work then. I mean, subject to what your learned legal advisor says, I think the new licence would only take effect from when those two licences were surrendered.
Are you saying they should both come into effect on the 1st of...
Third.
No, your application is for the main licence to come into effect on the 1st of August.
Yes,
But the post office can't come into effect till the 3rd of September,
that's
which
correct.
is a month later.
That's correct.
That's the difference,
Yes,
if
absolutely.
I've understood it right.
Yes, no, that's absolutely correct,
Yeah, yeah.
because the project, the cafe and the operating space is anticipated to be ready from the 1st of August.
Yeah.
So hence the reason we need to be doing those licensable activities from the 1st of August. But the post office part can't join it until the 3rd of September. I can't surrender the post office until the 3rd of September.
So that's the souvenir licence,
Yes,
you mean?
yes.
Chair, through you, could we therefore ask for a condition that both licences are surrendered no later than 28 days after the 3rd of September then? Would that work for the applicant?
Well, you could ask that. The committee can decide.
of course.
Yeah.
The second question, Claire, Chair, purely for purpose of clarification, I'm grateful. Colonel Mott and I have had a few chats over the last week or so. He mentioned to me a club premises certificate, which doesn't seem to be referenced in the application. Just for everyone's benefit, could he just tell us where that is and what it is and whether that's part in any way of this application?
No, it's nothing to do with this application. We've got a club premises certificate for the Chelsea Pensioners Club, which is the welfare facility where the pensioners use, throughout. And again, I'm the designated premises supervisor for that certificate. But it's nothing to do with this application.
Thank you, Chair.
We're now going to have a 5-minute break.
Thank you.
Please be back here at 11:01. Thank you. We are now going to have Alan Thomas will speak, but our solicitor, Heidi, has a question she needs to clarify first.
Yes, thank you, Chair. Just in terms of the Soane stable yard, which includes the visitor centre, the post office, the shop and the cafe, the standard hours would be from 10 in the morning to 1700, other than the 50 occasions a year when it can go up to midnight, although the courtyard would close at 10 p.m. That's correct, isn't it?
Yes.
Yeah. Also, the museum and exhibition centre, these aren't identified on the plan. Where are they?
Yeah, they're on the western elevation on the plan.
So are they included in the...
That's all the buildings around that courtyard. So the cafe, the museum, the exhibition centre, they're all the buildings around the courtyard.
So if we go to Plan 69, we don't need to put it up. And they're not mentioned on page 72. Yeah, so on page 72, you've got the Soane stable yard. Where is the exhibition centre and the museum in relation to those?
So you looking at the plan there, you've obviously got the central courtyard. You've got the cafe marked out,
Yeah.
and then the visitor centre starts the room immediately after the cafe into the corner, and then it's a walkway all the way through into the shop and post office.
So that's outside the licensed area?
Yeah, yes, that's not a licensable area. So
They're not licensed. You're not doing any licensable activities. You're not selling alcohol.
We're not selling alcohol in those spaces.
Right. So that's museum, exhibition centre. Okay. Thank you very much.
Thank you. Okay, now for the objector's case. Alan, would you please go ahead?
Chair,
You have 10 minutes.
Chair, thank you. I represent the Macmillan family who sit behind me here. Their representations were at pages 89 to 96 of the report. As you'll have seen from our submissions, there's been significant confusion arising from the proposals. A good example is at page 50 in relation to Part D of the operating schedule, which says, in terms of further details, this was not a permission in the existing licence. We'd like the opportunity to explore better boxing events for the Chelsea, and then it's cut off. But importantly, Chair, it says indoors and outdoors, and we were rightly concerned that on that basis that could have applied to Burton's Court. There has now, that part of the application has been withdrawn. We're incredibly grateful and relieved for that. And we've managed to find compromise as set out in the conditions before you. That was our greatest concern, the boxing and wrestling, which, to be frank, has made us very suspicious. We are less suspicious now, but we are here to make sure that everything that we've agreed is reflected on any licence that you might grant. We don't speak for others who are more affected by Soane Stanley Yard, but we just speak for ourselves in terms of where we live in St Leonard's Terrace. We've been able to clarify, and I should point out that the applicant has withdrawn non-standard timings, which were actually on the existing licence later in the evening, again for which we're grateful. So those only apply now in the mornings and not in the evenings. But most importantly, those non-standard timings in any event did not apply and will not apply to Burton's Court. The use of Burton's Court is dealt with in conditions 25 and 26 of the existing licence and 49 to 50 of the new. And if I just might summarise what that said, that the sale of alcohol in Burton's Court, it's Burton's, the internet says Burton, it's Burton's, no apostrophe, Burton's with an S though. Sale of alcohol in Burton's Court shall only be provided in conjunction with the provision of sporting events is the current wording. We have agreed with the applicant that that is finessed to read cricket, tennis, football and other ball games, and then between the hours of 10 o'clock and 8 o'clock during the winter and until 9:30 in the summer. But the non-standard timings do not override those conditions. And then in respect of the conditions in respect of regulated entertainment, we have agreed an amendment which reflect how the premises currently operates. To make it clear, we in St Leonard's Terrace, we haven't been significantly affected by noise, music. It's clearly a case of intensification that we were worried about. If it's just going to be the status quo, we are happy with that, but we need to make clear that the existing conditions in Burton's Court in relation to the hours and how alcohol is sold must be maintained. We are less concerned in relation to Soane Stable Yard, but I know there are others here that are more concerned. The two remaining issues are therefore off sales and late night refreshment. In respect of off sales, again, that doesn't override the extant conditions in condition 49. So if there were off sales, they would not take place any later than either 8 o'clock or 9:30 p.m, depending on what time of the year it was, and they would have to be in sealed containers only. In respect of late night refreshment, that has now been amended so that it's indoors only. So, Chair, in summary, from the Macmillan's family point of view, they were rightly concerned the impact that boxing and wrestling in particular would have on them. That was not mentioned in the residents' meeting, and it did come of somewhat of a surprise, hence why most of us are here today. But we are incredibly grateful that that has now been withdrawn, and the existing condition, which must have been imposed for a reason in the first instance when the licence was granted, has been reinstated and will apply to the new licence. There will be no change of use or hours in Burton's Court, and I've read out the conditions which we've agreed, and some of the others you've seen have been highlighted in red, and perhaps there'll be some further dialogue and discussion when your learned legal advisor goes through those at the end of submissions. Again, and as, or if not more importantly, that the non-standard timings do not apply to Burton's Court and do not override these conditions. Chair, we're of course happy to answer any questions that you may have. I do hope that assists.
Thank you. One moment. I would like to ask you a question. Since we've now discussed the boxing and wrestling, would you consider giving them the opportunity to have one boxing event per year for charity?
I'm afraid it's not in my gift, Chair. That, unfortunately, has been withdrawn from the application. There was that could have been a conversation that could have been had, but the conversation wasn't. It didn't go down that route. I can't accept that today because it's been withdrawn. Our concern in terms of boxing and wrestling is threefold. Firstly, in the application it was open-ended. It was to 11 o'clock, indoors and outdoors, including Burton's Court, for up to potentially 5,000 people, because that's what a premises licence allows. Secondly, there was no discussion of any frequency of events or the type of event it would be. And if that had been put in the application, that might have been... It's lay people making an application. We're not saying any of this was deliberate or spiteful. It was just clumsy at worst. But I I'm afraid now that the activity has been formally withdrawn and we've come here on the basis it has been withdrawn, I can't see how it can be reinstated at this juncture. We are also concerned about the impact of people, not just the impact of boxing and wrestling in Burton's Court, but the impact of any boxing and wrestling in the whole of the site in terms of customers departing, parking, etc. And that was covered in the RBA acoustic report. But I'm afraid, Chair, with greatest respect, you're absolutely right to raise it, but I don't think it's a matter that can be accommodated today.
I'll ask my solicitor to comment on that.
Yes, unfortunately, I agree that could have been something that was negotiated, but as it's been formally withdrawn, you can't. It's not before you. But we will hear from the Colonel to see what his view is.
Chair, councillors, you know, if I could just comment on that conversation, please. Firstly, on page 50, obviously, the way it's printed out, it finishes on the word Chelsea. What was actually on the submission after the word Chelsea was Chelsea pensioners on main site only, you know, to support that application. The Royal Hospital is happy to leave it exactly as it is, and we've withdrawn the boxing because I don't want to cause any unnecessary concern. If the Royal Hospital wanted to move down the route as a charity event, the Royal Hospital would liaise and communicate with the local residents and apply for a temporary events notice, because our numbers would not exceed 499.
Can that be done as a 10?
Yes, it can be done as a 10.
Okay, because that would make sense, because a one-off event charity for the forces, I think, is important. And I'm sure Mr. Thomas would agree with that.
It was the open-ended nature of it. Colonel Mott absolutely has the unfettered right to apply for temporary event notices, which will be the subject of comment and censure from the responsible authorities. And in terms of that sort of number, I don't think that would be a concern for us in any event, but I think that's exactly the way to deal with it. And perhaps in hindsight, it's not for me to say, to point out the hindsight of the applicant, but that possibly would have been the easiest way of dealing with it. I don't think, with respect to the applicant, they realised the furore that would have caused it. It is, I think, quite innocent in that respect, but I'm afraid that's the only way we can do it today.
The only comment I would say is that the application, to be fair to the applicants, they did include, they did replicate the restrictions on the Burton's Court. So they were in 22 and 23. So those conditions were mirrored from the original licence. So it was quite clear that they, any additional events couldn't override that.
Well, yes, to an extent. But if you look at the reading of the existing licence, and this is why we want to fine-tune that condition, the existing condition says provision of sporting events, which could easily include something like boxing and wrestling. And we wanted to be absolutely clear that that ancillary activity, the sale of alcohol ancillary to events, is nothing to do with any type of sport of that nature. It's simply what they're doing at the moment, which is cricket, tennis, football, and other ball games. It doesn't, by the way, that condition doesn't apply for things like school sports day. That only kicks in respect to the sale of alcohol.
The only thing I would say is that on the licence, there's already a condition which says no boxing or wrestling.
Yes.
So if that's the two issues you were worried about, that's been reinstated. So it's questionable whether you need to actually alter, whether you really need to tie down those sporting events, because you already hold a licence with sporting events, and I know the suggestion is that Mr. Thomas wants to restrict, define those sporting events, but the members are going to listen to what the residents have to say, but that's an issue that I'll come back to when dealing with conditions, because you already have a licence with sporting events which is not defined, and you're not legally represented, so I have to be fair to everyone in this hearing. So perhaps you could give that some thought.
Chair, can I just address you on that point? This is a new licence application. Obviously, the provisions in the of the existing licences are relevant, particularly in relation to intensification. But it is a new licence application, and therefore you will determine it on its merits. But again, it's the same point as the boxing and wrestling. We have come here today with this condition and all of the other conditions, apart from those right at the end, which have been agreed between the parties here and have been submitted jointly to the licensing subcommittee on Monday. And again, Chair, on the basis that it's already been agreed, for all I know, other people might have come here and had something to say about the sporting events. I know that Gisela is keen for that definition or something very similar to be adopted. So on the basis that something's already been agreed and sent to you in writing, we've effectively acted to our detriment in that respect by coming here on that agreed basis. So we would ask you, please, to go with the amended wording, which is the status quo. Because there is some, it's not as if the case that there is no intensification of use in this licence. There clearly is some intensification of use. And this, as one thing, sort of mitigates or balances out any such intensification.
And just coming back on that, so as you know, with all licensing hearings, parties present, in commas, agreed conditions to the committee, but the committee has total discretion as to decide what is appropriate and proportionate conditions, and you know we did this on the roof gardens very recently. So the committee is not bound by the terminology of the conditions that have been agreed outside this forum. It's the committee's job to decide what's appropriate, and they'll listen to every party, and obviously what you've just said will be taken into account.
Chair, I don't disagree that it's in your gift. The only point perhaps I was slightly clumsily making before is that there might have been people who wanted to come today that haven't come because they've seen this wording in there, and therefore that would be to their detriment. But I'll leave that with you, Chair.
Just for clarification, I'm the chair, and this is our legal advisor.
Was that pointing in the wrong direction?
Yes.
Addressing it to you, Chair.
Thank you very much. Next, Gisela Gledhill, please.
Thank you, Chair. I live in St Leonard's Terrace and have done so for nearly 30 years. I run the St Leonard's Terrace Residents Association, and the Chair, Catherine Manning, is also present today. My concern with the licensing application is Burton's Court, and very little has actually been said so far about Burton's Court. Burton's Court, together with the main grounds and Royal Avenue, make up the Royal Hospital estate in Chelsea. St Leonard's Terrace lies to the north of Burton's Court. It comprises about 40 addresses, and most households in the street are members of our Residents Association, and I therefore speak on their behalf and also on my own behalf. As Colonel Mott has said, the Royal Hospital organised consultation meetings with local residents' associations, and I've attended both these meetings. One of the items on which we were briefed were the plans for combining the existing licenses into one, incorporating the St Stables block, which will house a new cafe. We were told that apart from inclusion of the St Stables block, there would be no changes. I specifically sought reassurance in respect of Burton's Court. This part of the Royal Hospital estate has much more restricted licensing activities and hours. They have so far not been referred to, and what applies to Burton's Court is the sale and supply of alcohol and live and recorded music only, and only in connection with sporting events, and not later than 9:30 p.m. in the summer months. It never came as something of a surprise when details of the application were circulated by email and posted around Burton's Court. In the introductory sentence, the notices referred to main grounds and Burton's Court, and then listed the activities sought in respect of the main grounds. There was no reference at all to the more restrictive activities applying to Burton's Court. Needless to say, the wide range of activities relating to the main grounds and the long opening hours caused major alarm amongst residents. The streets around Burton's Court are residential, and any change to the status quo would have a very detrimental impact on the local community and cause significant nuisance and other problems. The number of objections lodged by residents and the range of issues raised, I think, speak for themselves. Not only was there confusion over what applied to which part of the estate, but there was also the addition of boxing and wrestling, and we've talked about that, and the extended hours. When we had our meeting, as Colonel Mott said, these issues were not raised at the meetings. Burton's Court is at present used for sporting events such as cricket during the summer. There are tennis courts which can be booked on a fee-paying basis. The Army occasionally uses the grounds for football, and some local schools use Burton's Court for their sports activities. It is widely used by local dog walkers. Burton's Court becomes a massive car park for exhibitors during the Chelsea Flower Show, and it was also used for VIP parking on the day of the late Queen's funeral, and occasionally a helicopter lands on some emergency mission. When there are sporting events in Burton's Court, participants, spectators, are often permitted to park within the premises, which means less pressure on our residents' parking spaces, which is, of course, very welcome. The currently permitted uses of Burton's Court in general cause no significant nuisance or disturbance for residents, and we would be happy for these to continue. However, any extension would be a major threat to our local amenity, especially if this involved big crowds and late-night events. It is therefore important that the license makes quite clear what is permitted where. So, in conclusion, I would like to make 3 points. Firstly, there needs to be total clarity on what activities are permitted where within the Royal Hospital estate and under what conditions. Secondly, this objective could be readily addressed by relatively minor amendments to the wording of the license. The latest draft I've seen now draws attention to Burton's Court in the list of activities for the main grounds, which helps a bit. However, I still believe that for clarity's sake, it would be preferable to set out the license in 3 separate sections. The main grounds and the Burton's Court and Royal Avenue. This would remove the risk of misinterpretation and confusion. I suggest that most people who read the license do not get to what is now General Condition 49 and Condition 50, which deal with Burton's Court. They would therefore not pick up the more restricted terms applying to this part of the estate. It also seems rather odd to me that substantive issues of what is permitted in Burton's Court and Royal Avenue are relegated to general conditions which deal essentially with administrative matters. And the third point I would like to make is there needs to be a clear definition of sporting events to avoid unwanted consequences. Cricket, tennis, football, RK, and school sports should also be allowed, although they would generally not be relevant to licensing activities except possibly on sports days. So, in conclusion, if these points can be addressed satisfactorily and subject to what Mr. Thomas has said, I would have no objection to the application by the Royal Hospital. Thank you very much, Chair.
Thank you. Next, Catherine Manning.
No, Gisela has spoken on my behalf.
She spoke for you. Great. Thank you. Paul Lever, are you speaking?
Chair, thank you very much. At the outset of this meeting, I believe that you personally admitted some confusion about the application. That rather encouraged me because I didn't like to feel that I was alone in finding it extremely dense and difficult to follow. There is a huge difference between the different premises involved, between Burton Court and the main hospital building. And it wasn't at all clear exactly what events were going to be permitted where. Had the application requested a single boxing event at the Royal Hospital per year, we would certainly not have objected. I think it's a pity that the procedure doesn't seem to have made that possible, and I hope that they will apply for a temporary license. There is a difference between 5 days of the flower show and a rock concert. Again, it seemed to us in the original application that it would have been possible under its terms to hold 30 noisy concerts a year. That, for the Chelsea Society, would have been simply too much. I understand that in the way that the terms of the licence have now been clarified, that will not be possible. But I think it's a pity that local residents' associations and amenity societies like the Chelsea Society, we're not a residents' association, but we do have over 1,000 members, were presented with an application which raised the spectre of things which were not planned, but which it seemed could be undertaken on the basis of the wording of the application. There may be lessons in this for the way that future applications are drafted and discussed. As to what the Chelsea Society's position now is, I would support the comments made by my neighbour from the St Leonard's Terrace Association. If it can be made slightly clearer what exact conditions apply to Burton Court and what to the rest of the site, and if it is clear that there will be no change in the regime for Burton Court as regards the provision of alcohol and so on, then the Chelsea Society would not have any problems. We wish the Royal Hospital well. We understand its wish to broaden the scope of its events, but I think there has been a good deal of misconception or misunderstanding about what is actually contemplated, and I hope that the terms of the licence will now clarify that. Thank you.
Thank you. That was really helpful, actually. So thank you. Michelle Van Tolder.
Thank you so much. I'm very pleased I came here today because, like a lot of the objectors, I was very confused as to what was being asked for. Unlike some of my objectors, I object even more strongly now. So I live on Durham Place, and I speak for a number of people who have objected, including the Beck family, Andrew Hunter, Lady Angela Neville, and we're all housed within Durham House on Durham Place. I actually was unclear, and I thought that the Soane stable yard was on the other side where the current post office is, and therefore, you know, perhaps the disbursement of partygoers or concerts, etc., would be at the other end of Royal Hospital Road and up to Lower Sloane. But now that I realise it's right at the top of my street, less than a block from my home, I'm more concerned. So there are a number of pay and display car parks on Burton's Court. I could imagine they're normally used Monday to Friday, 9 to 5, by tradespeople and people visiting local residents. I can now see that they will be used well into the night with people attending these events, so there will be all the noise associated with cars leaving late at night. I'm also unclear exactly as to what hours we're talking. When we originally saw, and again, this comes back to how local residents were communicated with. The first I ever heard of this was when one of our residents, the Beck family, noted that there was a sign attached to Burton's Court. Can I also add, we can't actually get access to Burton's Court, even though we live directly opposite it, so we see people enjoying it all day, but I can't take my own teenage girls in there because I can't even get on the waiting list. So they brought to our attention that actually there are these merging of licenses, and it meant late hours. From what I understand from this new application, it's even later. I thought it finished at 10, but now we're talking about potentially finishing at midnight. We currently have a lot of issues with the Surprise pub, which we're at the top of the Christchurch Street end. So we have people leaving between 10 and 11 o'clock at night. So to have people potentially leaving between 10 and midnight from another premises that will go straight past our residences, I would be fairly certain if the people on Ormond Gate and Durham Place understood that this wasn't just about Burton's Court, that actually there is a venue going to be at the top of our street, there would be a number more people here today. I think it's also worth noting that we do currently hear the noise coming out of the Great Hall. It took me a little while to realise that it wasn't a local neighbour with a large boombox and a bass nearby, and that actually it was half a block away in the Great Hall. To now think that that is going to potentially come closer, where I now understand the sewing court is going to be, that's a problem. And I noticed that we spoke about, obviously, the disruption to the resident pensioners, which is of paramount importance to everybody. I now note from you kindly pointing out and putting the diagram on the board that actually we would be closer than where I think the pensioners are actually housed. So local residents will be even more affected than the pensioners with the comings and going from this event. I don't need to reread my statement of objection, which relates obviously to noise and nuisance, and our teenage children which walk directly on the school walk. The school run is up and down Royal Hospital every day with hundreds of children and parents. They very well may be affected with the increased traffic that's required to service this amenity and the events. I also didn't realise the frequency, up to 50 a year, that's one a week. So on top of the events going on in the Great Hall, which I can already hear, and which at the moment are tolerable because it is so infrequent, the thought of having on average one a week, in addition to all the disruption from the flower show, which is fabulous and we absolutely support, it becomes less of a quiet residential nighttime space for residents, and it will create, I believe, problems and antisocial behaviour, which we already have from the Surprise. So it becomes an element of volume within the local area. Thank you so much.
Chair, would you mind if I added one more point just to the end of my submissions? I think it would be within my 10 minutes, if I may.
Of course.
That's very kind of you. Thank you very much. Chair, I just want to finish off on that sporting event definition point and what Heidi asked you or suggested that you might want to revert back to the original wording rather than the wording that's been agreed between the parties. Chair, can I ask this? Yes, it's absolutely in your gift to grant what conditions are appropriate and proportionate. That's what the law says. But you've got to take into consideration what's been agreed between the parties. The Macmillans have spent a significant amount of time and money protecting their amenity, particularly that this was an application that had not been consulted on. That's where this all happened. The consultation was one thing, and then the application was something else. And we've spent, again, with huge appreciation to Colonel Mott, a massive amount of time negotiating all of these. We've been through every one of these conditions to make sure that they are proportionate, appropriate, and enforceable, and that they're agreed. And it's on that basis, it's only on that basis, that we've been able to come to agreement and take a neutral position at this hearing today. These amendments, the amendments to change the words from sporting events to cricket, tennis, football and other ball games, are extremely important to us. And it's absolutely right that all of the agreed conditions should be transposed upon any licence that you may grant. Otherwise, what would be the point in having these details between the parties? I know that as a committee you encourage the parties to come to agreement where they can, and we've been able to do that, but it took a lot of time and effort from both sides to come to agreement, and all we ask for today is for you to reflect that agreement in any licence that you may grant. There's no reason not to, because they've been agreed between the parties, and that was the only final point I wanted to make, and thank you very much for letting me make it, Chair.
Okay, now we'll have questions from the committee. Councillor Knight?
Can I just clarify something quickly with the applicant before I ask the question? I was just going to ask, from events previously in the past, is the gate you're using changing from what Michelle has just raised?
Absolutely. The gate that we're going to be using to come out of any of those events in the Soane Stable Yard will be Chapel Gate. So the individuals will be managed down the north front and out of the centre gates to allow us to disperse the guests sensibly onto Royal Hospital Road, avoiding those guests going directly opposite Chelsea Gate towards, you know, the area where Michelle has just raised as a concern.
Can I add something as well to that? Depending on the event, guests can book taxis which can come into Chelsea Gate and pick them up within our site and take them out. So if they're not getting public transport, if they're happy to get taxis, that keeps noise levels down as well. And for the Great Hall events, that's quite often what happens.
Is Chelsea Gate the one that's on the river?
No, that's Embankment. The Chelsea Gate is next door to the Army Museum.
Yeah, okay.
So on the Royal Hospital Road, you have Chelsea Gate, then Chapel Gate, and then London Gate.
Yeah, thank you. And I just wanted to ask generally residents, I know you've brought up concerns already, but have you made complaints beforehand about previous events that have been held over the years? And have those been formal complaints? Because obviously we've heard numerous just sort of talkings of events today, but the applicants very much said that there's nothing that's sort of changing in the type of event. So I just wanted to understand what experience have been of those events previously. Thank you.
We're fairly new residents, so we've been in our home for 18 months, and in that time I have definitely heard loud noise from the Great Hall. If there is an extension of the hours, and this is again what I'm not clear on, we've obviously tolerated it and absolutely not complained, because in our view it's the Chelsea pensioners. You know, there is a huge amount of goodwill because you know it's for a good cause and it's doing good things. But to think if that frequency goes up, we will start complaining. Because, and particularly, and you asked a very good question about the exit, as much as they may exit the next gate up, the most direct route to King's Road, which a lot of people will do to either get a taxi or to keep on partying or whatever they want to do, they will come straight past our house.
I'm going to have our lawyer answer your question.
Yeah, I mean, I appreciate there's been a lot of confusion about this application. As I said, I was a bit confused myself. But my understanding, there isn't going to be any extension of hours. In fact, it's the reverse. What they have done is cut back the hours. So they are entitled currently to have 30 events per year up to 1 o'clock in the morning. So they're entitled to that on 30 occasions. They have agreed not to use that as part of this licence. So the licence will stop at midnight. So it's the reverse, in fact. The hours have been cut back. So I just wanted to make that clear because I know that you're concerned about any extensions of hours.
Can I respond just quickly to that? So I understand that, and thank you very, very much for clarifying. So now the issue is not, well, it is still the hours, but the location has changed. So it is now going to be applicable to a building that's at the top of our street. Before, from what I understand, it wasn't. It was the Great Hall and those other areas that we mentioned. Now it's going to be in an area that is closer to residents than it is pensioners and people currently living in Royal Hospital. So it's changed, it's closer to us, and it will affect us, without a shadow of a doubt.
Does the committee have any more questions? Councillor Knight?
Be quick. Just to, if there was an ideal gate, I don't even know if this is possible, but I know there's lots of different gates to Royal Hospital, that you would wish people to leave for, and I don't know if geographically this could ever make any sense, but in terms of leading people out ways, I know there's busier roads that face either side, different sides of Royal Hospital. Is there a particular gate to you that I think that could make most sense?
Exiting's part of the problem. It'll be the noise of the music and the carry-on that is going to be our main objection. In terms of exiting, you could have them exit at the Bullring, but that's so far away from the actual event, and it puts people down onto the embankment, and obviously, no one wants anyone at risk being dumped onto the embankment late at night. But, that would be fine from an exit perspective, but given that I can already hear the noise going on in the Great Hall, it's going to be the noise, and even though I understand it was at 1 and now the hours will be shortened, the frequency will go up and the location is different.
Thank you. And
the Bullring exit was the favoured exit until I think relatively recently. Indeed, the original license stipulated that should be the main exit for various events. The exits in Royal Hospital Road inevitably create problems when masses of people come out of from events. And I think one of the solutions that needs to be addressed, and needs to be addressed really effectively, is a proper traffic management plan. I mean, I have come back from an event and come across Battersea Bridge and tried to get to my house. And there were so many parked cars there. The whole place was totally chaotic. I couldn't turn into the street leading to my house because it was all blocked. So I think there is a sensible solution that is available, and that is appropriate traffic management plans in respect of each of the events. And I think that would to some extent address the problem. You asked earlier on about have there been any complaints. There are regular dialogues going on with the Royal Horticultural Society in respect of the flower show, and the flower show has, progressively improved. They have taken into account all the comments we have fed back on a regular basis, and that has been a much more cooperative and constructive arrangement. But there have been plenty of complaints in the past about traffic, about noise, about disturbances and everything else. But so it is not a non-event complaints. They are there, but I'm pleased to say that things have got a lot better, certainly with the flower show.
Thank you for sharing that. Councillor Knight, you said you had one more question?
It's just in terms of, a number of you have mentioned defining the sports as something you'd like to see as part of the licence. And I'm sort of very much in the mindset of what Janet raised about that I do think it could have been clearer within the document as to the boxing, because I think that's a sad loss, but hopefully there can be a way of working around that if it was an event a year. But just understanding what sports you're concerned about that you feel the need to define, if that makes sense, because it doesn't feel like there would be any other sporting events that could be causing issue here, but just to understand that.
May I address that?
Go on.
I think one of the concerns was raised by the fact that the license application suggested that the main ground licenses would apply to Burton's Court. And anything that involves large crowds, late opening hours, are an absolute no-no. We are a residential area, and noise and activity and so on beyond a certain hour in the evening is not acceptable. And likewise, pressure on parking, traffic, everything else is equally not acceptable. So I think, that is absolutely important as far as we are concerned. You mentioned the fact that, there couldn't be much else. I'm not entirely sure, but the very fact that the application, or at least the consultation in connection with the application, suggested that the main ground licenses could be cross-read to Burton's Court, raised alarm, because there are other things happening in the main grounds that certainly would not be acceptable for Burton's Court, and a cross-reading of licensable events would be a major problem.
Giselle, I'm so sorry. Did you want to advise, Heidi?
Yeah. Often with licenses, I appreciate what you say, when there's a notify of an application, you basically have to notify of the licensable activities you want. You don't see the conditions that actually restrict the operation of that license. So what they're asking for is exactly the same conditions in relation to Burton's Court that you had on the existing licence. So you do have safeguards. They are going to be maintained, but they wouldn't necessarily have been listed on your notice that you would have seen, because it's quite a bland notice, unfortunately, and I accept there has been obvious confusion, but in terms of Burton's Court, there are two conditions which were on the original licence which restrict the area of Burton's Court. So that's how you are protected, and they are being maintained by the applicant. So I just wanted to reassure you in that sense.
Just elaborate on that, please. What are these conditions?
Yes, so on the original licence, there was conditions 25 and 26. They're on page 27. Have you got the main committee pack? Are you there on page 27? So on page 26, it's from 25, 26, 27 and 28. This lists all the restrictions that are applicable to the licence of the entire area. And you can see under condition 25 and 26, these particularly relate to Burton's Court. So they are limiting the hours of use there. And that there's complete restrictions. It tells you that they're limited to 8 o'clock, 9:30 during the summer months, and also condition 26 says regulated entertainment also is restricted to 8 o'clock. So even though they've got a midnight licence, that doesn't apply to Burton's Court. So I just wanted to make that clear to you. The devil is in the detail. It's the conditions on the licence.
Chair, I understand that point. I obviously helped drafting these conditions and making it clear that the changes don't apply to Burton's Court. Can I just pick up on the point I've made twice, perhaps badly already, and it's this. Whilst boxing and wrestling is specifically prohibited on the licence going forward, as it was before, we have been pricked into being very cautious and suspicious about this application. And the mere mention of sporting events, notwithstanding it can't be boxing and wrestling, could be something else. And we are concerned, rightly, because of the fact that it wasn't in the original consultation, as to what that sporting events could potentially mean. And Chair, it's a legal point which I'm sure you'll take advice on. But having agreed these conditions and put them forward as part of the application as amended in the additional submissions by agreement, that has effectively now amended the application in the same way that we discussed earlier, and your learned legal advisor agreed that the boxing and wrestling, having been withdrawn, couldn't be reinstated and granted even on a limited basis today. It's the same point about the sporting events condition amended as we've asked it to be amended. Because once wording has been agreed, that then amends the application, and the only thing that can be granted lawfully are conditions which are consistent with the operating schedule and any additional conditions that you may want to add. So that's the starting point. When you make an application, you can only grant it consistent with the operating schedule. And what's happened, because these conditions have been agreed between the parties, that application has therefore been formally amended and put before you, and therefore you're only able to grant the proposals that have been amended.
Sorry, Mr. Thomas, I'm going to disagree with you there. The application included those conditions. It's on page 10.
But the application has been amended by this. That's the reason why we're here today. We went through all of that consultation with the applicant. We haven't heard from Colonel Mark. I'd assumed that, having sent these, he's happy with the conditions that we've agreed on. And
there's a difference between removing a licensable activity, which I agree with you, so they've removed the boxing and wrestling. They can't resurrect that. But when it comes to conditions, the conditions have absolute discretion as to decide what is appropriate and proportionate. They obviously take into account what all the parties have said. But it is within their remit, as you had said earlier, they do have the discretion. It's not the same as removing an actual licensable activity. They have removed that activity, but in terms of the application, you were incorrect to say that those conditions were not part of the original application, because they were. They were on page 10.
Chair, they certainly were in the original application, but the point I'm making is that those conditions have been agreed, and therefore they form an amended part of it, hence the thing. I would be disappointed, if I can put it in that way, if the applicant was asking you today to go back on that agreement. I appreciate the point that Ms Titcombe is making, but I'd be disappointed if the applicant was now taking a different view, and perhaps that can be clarified, because that might change our position significantly on all of the matters that have been discussed, and perhaps you should hear from him.
I just have one more question. Have any of you filed a complaint for noise and nuisance? No. And so basically, would you agree that your objections are based on conjecture?
No, Chair, they're based...
I'm asking everyone, thank you.
Sorry, I mean, from our point of view, Chair, they're based upon a legitimate concern that there's going to be an intensification of activity, even from Soane Stable Yard. So it's definitely not conjecture. It's a belief that some of these activities could adversely impact. But I'm going to let the residents speak on their own account.
Okay, a belief, but it isn't based on fact yet, because they haven't made any complaints.
Well, it's based on the acoustic report, Chair, which you've got in front of you.
Mm-hmm.
If I may, Chair,
Yes.
there certainly has been reason for complaints. The fact that they haven't been formally signed, submitted, doesn't mean to say that the reason for complaint hasn't arisen. I, for instance, recall one particular circumstance some years ago when there was some event on Burton's Court, and people started using megaphones. And the noise from the megaphones was such that I was not able to have a conversation at a luncheon table. I was giving a lunch at the time, and we couldn't hear each other because the noise was so intrusive. So the fact, that we didn't file a complaint at the time doesn't mean to say that the underlying cause for the complaint wasn't there.
Okay, I think perhaps when we have our conditions session, I would like to suggest that you have recourse to be able to phone up the premises and tell them on the spot, because you were having lunch, it wasn't after hours, but on the spot, that we will have them provide a mobile number for complaints so that it doesn't even have to be complicated. The problems can be nipped in the bud, and I'd like to suggest that as a condition when we do our conditions. Thank you. Now, any questions from our legal advisor?
Chair, I'd like to ask some questions, please. Thank you. Okay, thank you. Just to general objectives. So I have a couple. There is, again, I do feel like we're asking the same things, getting the same answers. My real overarching question is, what is going to change in your view, and why do you think that? There's been a lot of, a few mentions of intensification. The hours of the license are not getting longer. I know in the original objections, there's mention of light pollution, more traffic, more noise, both from dispersal and from events. As I understand it, there have been 2 years where you've had pop concerts 4 times a year, but no complaints. And I'm sorry to say that as a committee, we can't act on anecdotal stories. We have to actually work on complaints. So please, I encourage everybody, all the time. We're always doing this. Please complain. Call environmental health. Call the operator. We need a record of it. Or we can't really act on it in the same way. But yeah, so just to excuse a digression, but the overarching question is, what is this intensification? What's the nature of it going to be in accordance with how the license that's in front of us now? What's that based on?
Chair, I can speak on our account that we want to make sure that the status quo is maintained, and perhaps it's more of a question for the applicant to answer, is that what sporting events they are proposing. Because, as I've said before, what we are concerned of is that the whole ethos of this application was an intensification. I know it's being amended now, but we are worried that there is enough vagueness within those conditions, including the definition of sporting event, to allow things to happen which haven't happened in the past. And in terms of it being appropriate and proportionate, the applicant has agreed to defining what those sporting events are, and perhaps the question is best asked of him as to what those sporting events would be, because our understanding and agreement was that they would be limited to cricket, tennis, sporting and other ball games, at least when alcohol is sold.
Can we follow that up with the applicant, or is it for later? Okay, so please answer.
Chair, yes, no, absolutely. The Royal Hospital doesn't want to go and divert at all away from the agreed conditions that were submitted on the 24th of June. And just for clarity, we have cricket, we have football, we have tennis, and the only other games that the Royal Hospital would see happening on Burton's Court would be potentially for the schools some form of netball and basketball, potentially a paddle tennis court, again another ball game. And the pensioners do, the schools, football and tennis, rounders, the MOD have asked to do rounders, the schools potentially doing basketball and netball, for the members potentially introducing paddle tennis, again, which is a ball game, that is it. We're not looking to change anything. It's just ball games. Oh, and sorry, and the pensioners, I think it's on a Monday evening, do walk-in rugby, again with a rugby ball. So there's nothing more. So I'm quite happy the way that condition was reworded, and that's why I suggested other ball games, just to give everybody peace of mind.
Okay, any questions from the legal advisor?
Yeah, just on that point. At the moment, you've got an unrestricted licence in terms of the sporting events. And I can understand from the residents they want to try and determine what sporting events mean. But the list you've just given to me is wider than in this condition. And normally we wouldn't set out a condition listing all the conditions. So, for example, if you have anybody there who might have a glass of wine at the Rounders match or the walking rugby at the pensioners, you could potentially be in breach. Unless you think ball games is sufficient to cover all these.
Please put your mic on.
Sorry, Chair, I didn't realise it was myself. Yeah, we're happy with ball games because all of those games that I've just discussed there, it's absolutely with the ball, and we don't see anything else. And if that puts peace of mind for the residents, we are quite happy to work alongside with the residents. And like it has been mentioned, we've gone through these conditions in fine-tooth comb, and we have amended some of the wording, to please both parties, so how we can operate, but most importantly as well, just to put peace of mind for the local residents.
Sorry, can I just say one thing? Councillor Benton, when you asked your question and you were talking about what in substance is going to change, I feel we've addressed part of the answer, but my concern still remains with the Sloane Yard. And we're talking about what's happening in Burton's Court, but I feel like we're missing that these events are moving out of the hall, well, still in the hall, but we're providing another premises and the location of that is changing. And I think if residents had understood, the objections would be greater in here. And I think it's only today, through me coming here, that I actually understand the extent and the frequency is going up of these entertainment that, as you rightly pointed out, we should have objected to. We didn't, because there is this goodwill. That goodwill is going to change, and we will start objecting, because I do hear the disco beats late at night out of the Great Hall. We are now going to replicate that event in another part of the Royal Hospital that is closer to residents than it is to pensioners, and I feel we're just missing that here today.
One more question from the committee.
Thank you so much, and I appreciate this is going on. So you've partly answered my question. So you specifically have heard music, because we've heard that there's an 80 decibel within the actual grounds being a limit. We can actually go further into that in the conditions possibly, when we talk about that, but that sounds reasonable to me. The other question, final question, egress gate, the existing preferred gate for exit that's being used at the moment. Does nobody live near there? Is that entirely nobody? Sorry, I know I should be asking the objector, so I'll ask you. Yeah, that not residential.
Sorry, can I address that? So that gate leads to nothing. So Royal Hospital Road and a blank park. So the only way you can get past that is to turn left or right. When you turn left or right up Royal Hospital Road, you will then be getting to the residential areas. So it doesn't matter that you're dispersing the people there into, if you like, no man's land. The fact is they then have to walk past residents. A lot of them will go east or west, and they will then have to turn to go and get a taxi and get to King's Road or go to the tube. Then the shortest possible route is then going straight past the residential housing, either on the eastern side of Burton's Court or the western side, where I am, on Ormond Gate and Durham Place. And had people understood that, I can tell you there would be many, many more people here today. So I'm very pleased that I've come here for clarification. But as I pointed out, as residents, we weren't consulted with at all. There was not a letter throughout thing. There was nothing. We were not invited to any meeting. It was only because one resident saw a thing on the side of the Burton's Court that I'm even here today. And I can tell you this will be a problem, and we will be objecting with every piece of noise now that comes from that event.
You're encouraged to do that, yeah.
Okay, I'd like to move this on now. Any questions from our legal advisor? Nope. Any questions from the applicant for the objectors?
Not questions as such, Chair, but I could clarify a couple of the points that's just come up to hopefully to reassure some people. Thank you, Chair. First of all, just going on to, I touched on it earlier on, the safety advisory groups that we actively engage with RBKC for any major events. We've actually increased the number from the flower show to now the 6 major events that have happened on the flower on the grounds over the last 3 years. And the traffic management plans is part of that, which are carefully scrutinised by the local authorities. With regards to the Soane Stable Yard, there are a number of differences to what goes on within the Great Hall and the State Apartments, which are listed in the revised conditions, in as much as there's no amplified music, there is nothing outside after 2200 hours. Everybody will go out of Chapel Gate, and naturally the majority do head east. We've got evidence of that. We see that from the other events, because that's naturally pointing them towards the Sloane Square. We don't have rowdy crowds on our events, and the numbers, as I explained, in the main is going to be about 40 people, corporate events, which will only leave in the main, as my colleague explained, by 2200 hours. And in our protocols, we do have clear directional signage, and it'll be asking people to be respectful as they leave the site, if that goes some way to try to reassure people. Thank you.
Thank you very much. At this stage, I'd like to ask our legal advisor to deal with any queries she may have, particularly regarding the draft conditions. And let's hope we can all agree.
Hello, so I just wanted to go through the conditions list. I circulated one a bit earlier before the committee, just because it's in a bigger type, so hopefully it's easy for people to see. And I just want to, so on the first page, if everybody's got that to hand, it looks like that. Have you got a copy? Yeah. Yeah. So I think I made one slight amendment to condition 10 by putting in the word "the." That's agreed, is it? Yes? Thank you. I'm going to ask the applicant first, Alan, if you can comment afterwards. 13, that's a new condition. You've agreed that, have you? Okay.
Yes.
And I noticed the word "proper request" has been taken out of number 15. Is that acceptable? The original condition had proper in, yeah. Okay. And I've just added the just for sake of completeness. In condition 19 is the one that's been changed, and that relates to, it says no independent sound. I think there might have been some duplication on some of these conditions, because I've certainly seen another one similar, so the committee will tidy these up. So I'm just wanting to make that clear. So you're happy with the fact that the word independent has been removed?
Yes.
Thank you. And normally, when you do these conditions, it says give rise to nuisance within neighbouring dwellings, but you've changed the wording to noise-sensitive premises. How do we determine what those noise-sensitive premises are?
It's more universal. I'm not seeking to change any model conditions that you have, Chair, but it's more universally word vocabulary for this type of issue. But our main point was that we wanted the same consistency throughout the conditions, whether it be neighbouring dwellings or noise-sensitive premises. Our preference for the definition would be noise-sensitive premises, but if it's going to be neighbouring dwellings, that the same definition applies consistently throughout.
Yes, so I mean it's a question of enforcement that is the issue. So you're happy for those to be either of those two words?
Yes.
Yeah, okay. And you've altered number 20. I've altered number 20 to just make it clear it's associated. That was a misspelling in there, and I will. The second point is the same as I've just mentioned about neighbouring dwellings. That's raised in 21 as well. And 23 is a better definition. I think it's all persons, staff and guests. Is this for every but there's no reference to what the terminal hour where the 30-minute bites. Normally it's the sale of alcohol. Does anybody have any comments on that? Or do we just leave it blank?
The reason for the amendment is that it wasn't perfectly clear as to what guest or attendee meant. And again, for the purpose of consistency throughout the conditions, we thought it was better just to call it persons, but that obviously excludes members of staff.
Yeah.
I think, certainly from our point of view, it would be better to have it 30 minutes later than, as you suggested, from the last licensable activity, because there might be some events where alcohol isn't sold, but there still be significant dispersal.
Yeah, so I'll add in the word last.
I'm so sorry, I didn't miss...
So is it the latest licensable activity? It's 30 minutes?
Yes.
Yes.
From our point of view, if the
okay.
applicant agrees that.
24 is just to make it clear. On 27, you've altered it to no music or amplified sound. I think I'm going to amalgamate conditions 19 and 27. I think there's a bit of duplication there.
Okay.
Okay? Right.
Yes.
And then the conditions 31 are the extra conditions you've offered. I've made a few tweaks to condition 34, which is the CCTV, just so that it's clear. In B refers to that you'll act within 24 hours, and then the next, at the end, it says within the absolute minimum of delay, which is inconsistent, so I need to make sure that's tidied up. I've reinstated number 35, the boxing condition.
Yeah.
And then on conditions 36 onwards are the additional conditions that you've put in your application. And I've raised the issue about whether it's neighbouring dwellings or the nearest noise-sensitive premises. I'll use that term in all the conditions. You've added a noise limiter device in 40, so that might be something that would help the residents. And before this premises can operate, number 42, the applicants are offering to provide a dispersal and external management plan, which is quite common. Now, you've included the term in the middle, recommendations on the part of local residents. As a lawyer, I don't like that reference because it gives rise to the issue of how many residents. Do you consult all the residents in the borough? Do you consult all the residents in X streets? It's too wide to be enforceable. So that is something that I would want to be removed. But you obviously do feed in your representations to environmental health and with the residents' associations. So I consider that the terms of the local residents should be removed. Alan, do you have any comments?
It's a term which might ring a couple of bells because you mentioned the other case that we were involved in recently, and I can't remember the exact wording that we used for that. It might have been the amenity associations. I wonder whether it would be agreeable that it refers to the residents who made a representation, or I'm open to suggestions on. I completely understand and agree your point. It can't be completely open-ended.
No.
But I think it's important that the people who've appeared here today and the others who've made representations have some sort of forum in it.
Well, it's a question of enforceability, because if you breach this, then you're liable for criminal prosecution.
You're absolutely right.
And I'm not trying to catch anyone out, but that's why it's always inadvisable to refer to local residents. That doesn't mean that you won't be consulted, but to have that in your condition is quite onerous, and it's something that I wouldn't recommend the committee to include.
Do you have any thoughts on a phrase, Heidi?
No, we always strike it out because it's enforceability.
But how do the people here then have any say in the management plan then?
Sorry?
How do the people here today and those that have made representations have any input into the management plan then?
Well, they can't have official input because this is a condition that needs to go through the responsible authorities.
I think I have the answer similar to the other matter that we were involved in. How about just defining the amenity associations in it? Because of course we will feed through the St Leonard's Residents Association and the Chelsea Association. So what that would mean, Gisela doesn't like it, ironically, but what that would mean is that if we have any comments, we would feed through them and they would make them, and then you would have due regard to it. But at least you've got a focal point of a defined term.
You can feed through your comments to environmental health because they're the guardians of this sort of plan.
I don't think I can take any further. I think there should be some reference to consultation and input from local residents within that, however it might be defined. But I'll leave that with you.
I've heard what you say, but I'm going to suggest to the members that comes out if they're minded to add this condition and if they're minded to grant the application. I'm going through these conditions. I don't know what the members are thinking or what they have in mind, but I have to discuss the conditions in an open forum.
We have a condition about residents' association meetings, don't we?
Yeah.
And how often are they going to be?
What's that?
It hasn't been discussed yet, but maybe we should talk about a condition that there will be either annual or every 6 months. Because since you're looking for input into management, which is not what the license is about, but I think we can have communication with the residents. I think that's what makes sense.
I think that's a standalone condition in its own right.
Exactly.
I mean,
and I think that makes sense because we need the input of the residents if and when, as well as open discussion about how things are going.
I think the two things are mutually exclusive. So yes, there needs to be regular meetings, as in they may never be required. But the point that Gisela just made is that she sees, and we see no reason why local residents, in whatever, however you define it, in my suggestion, I think Gisela's defined by reference to the Residents Association, why that shouldn't be in that condition. I don't know if you want to hear from Gisela more on that point, but I think she and I are in agreement on that. But we're also in your hands. Gisela, do you have any thoughts on why that should be included in that definition?
Well, we are talking about the dispersal and external management plan, yes? I mean, to me, this is in a similar sort of category to traffic management plans. And I don't see why local residents associations shouldn't be involved in communications about that and consultation on what is proposed. That's certainly how it works, for instance, with the flower show. We see the traffic management plan for the flower show. If we have concerns, we feed those in. And I don't see why, in the context of other events, this shouldn't work.
Colonel, can you elaborate on that?
Yeah.
How you consult the residents on, because it's normally part of the responsible authorities group, isn't it? It's the statutory group that feeds into the Chelsea Flower Show. How do you involve residents?
Thank you. In my opening comments, it's what I said, and we started it this year, is we certainly want an annual catch up with the resident chairs to talk about the upcoming event season and any concerns for us to feed back into the major event, major event hirers. Whether that needs to be twice annually on 2 occasions, so we're not only capturing the major event season, but we're also capturing how the on-site activities and events across the site are also being covered. I would rather it be that way.
Understood. So, I mean, this, I agree with Alan, this is a separate requirement because we're just agreeing the external management plan as a one-off, and then they have to provide any amendments. They have to send them to the council, which is standard. So you're not suggesting that you should, correct me if I'm wrong, if I've misunderstood, but you're not suggesting that you should be officially liaising with the Residents Association regarding this, are you?
That's correct.
Right, okay, thank you. Thank you. And then we've come to, I've just added that it should be complied with. So if you do make any revisions, then obviously that document should be complied with just in the similar way that the original document would. And then we move on to the Soane Stable Yard. Condition 44, is that open every day at those times? Yeah.
Yes.
And we've discussed where the plans are. And in terms of the Soane Stable Yard, condition 45, I've just made a few amendments to that. They're nothing controversial. I will remove the term visitor centre because at that stage I didn't know where it was, but you've explained it during the hearing. And then I've just made a few tweaks to 47 and 48. Yeah. The committee have heard what you've said regarding whether to define sporting events, and that's a matter for them to determine. In terms of condition 50, I noticed that you've made this condition a bit more restrictive because now it's saying that it's background. It should be background recorded music rather than just general recorded music. You have permission for recorded music, but you're happy with the background, are you?
I'm happy to leave it as it was, but again, I was just working alongside, the residents, if it made them easier to, to have background in there, because we don't have loud music in Burton's Court. So
well, no, you currently have recorded music.
Yes, no.
All right, so that means it doesn't have to be background. You've specifically asked for permission to have that. If you had background recorded music, technically you wouldn't necessarily need a license at all. So that's why I've queried the term background, whether it should be in there.
No, we'll remove the word background and keep it as recorded.
And I know, Mr. Thomas, you're going to say that it was agreed and that it should be...
I'm sorry to keep banging on the same drum, but it was. I know that Mr. McMillan, who can't be here today, felt strongly, as we had a meeting together about these amendments. And I unfortunately, without instructions, can't agree that. It's a matter for you. I think background, if it helps, I think background is difficult to define. At the very least, well, firstly, we would ask you to keep to what's been agreed for the reasons I've gone through before. But at the very least, the live music needs to be unamplified, which is definable and enforceable. Background is more difficult to enforce, I would concede.
Yeah, well, exactly. And I mean, the conditions have to be properly drafted to make them enforceable. So I would suggest that wording is removed. Background. What do you say about the retaining the word unamplified? Are you happy with that?
That's fine.
So I'll leave that in, and so I'll remove the background also from a bit further down.
Just to be clear, we're not agreeing to that. It's
No,
a matter,
I know that you don't agree.
Thank you.
Just,
I won't
just
suggest
one
that you have agreed, don't worry.
Just one comment. That
Yes.
when we have the cricket games and the cricket scoring, that has to be amplified. No.
The umpire...
Sorry, say that again?
The scoring, reading out of the scoring during a cricket match is amplified. It's not music, but it has to be amplified so the players can hear the score.
So would any of these conditions, well, it's not music,
No.
but then would you...
Would affect condition 51.
It would affect condition 51, and also there might be occasion if there was an emergency that you would need to use the amplification. You know, if there's terrorist plot or whatever it is. So I think there should be an exception in the case of an emergency. But do you need to use? You can use them up to 8. Do you think you need to use them after that?
No.
No.
So you're happy with that?
Yes.
Yeah.
And are you all agreeing the amendment to unless there's an emergency? Yeah, thank you. So the conditions that were in the original licence, but I didn't see here, I've added, just so that I've got a complete record. So this was condition 24 on the original licence, was about 30 events. So you are having the 30 events. You do want that, don't you? You want that to be retained in the...
Yes.
Yes.
But from 8
I think
till
that
10
was just
in the morning.
missed out.
Yes.
Yes. I'm not quite sure whether you need condition 53. You'll tell me whether it's applicable or not.
No, we removed it.
Okay. And the other possible condition was the surrender condition, which we've already discussed, but we've heard that you can't surrender it early because you've got the restriction on the 3rd of September.
We'd be happy with within 3 months if that assists.
Within 3 months of?
Of either of the new licence taking effect or the 3rd of September. So how about by the 31st of December, something like that? That should give plenty of time.
Would that be acceptable to you? That might be a way round it.
Yes. As long as the post office stick to the timelines that they've told us, because we're limited to that, to the 3rd of September.
Is there any possibility that that time could be pushed?
We're really in the hands of the post office. You know, the date that they've confirmed, the actual physical movement of the post office is on the 3rd of September, and all their resources are lined up for that. Hence the reason why we want to surrender that licence on the 3rd of September.
One alternative, I'm just throwing this out there, is that it could be, we could say that the main licence is surrendered by that date and not mention the second licence because you're going to surrender it anyway. I think that might be
That's fine, Chris. On behalf of the Macmillans, we're not really worried about the surrender of the off licence as much. It's the main licence, so that would be fine.
So I think I'll
from our point of view.
remove the other licence because you've got the problem about there could be a delay, and I don't want you to then be liable for criminal prosecution.
Well, I think the other interested parties would just welcome hearing is that having both licences potentially, both off licences potentially extant at the same time, wouldn't increase the amount of events.
No, that's right. So the only final condition that's not on here but's been mentioned is a liaison condition with the Residents Association. It's a fairly standard condition which the council likes. So you suggested that it should be once a year.
A minimum of once a year. I would very much support it.
Yeah, is there anyone else had any comments on that suggestion?
And the phone number.
We've got the phone
We've
number.
got the phone number, yes. Just
I would
pointing it
certainly
out.
welcome more than once a year.
What would you
more? I think twice a year would certainly be much better. I mean, one of the issues is, as and when these events happen, and you know, a sort of post-mortem of an event is quite often quite useful, and that certainly, for instance, happens with the flower show. We have a meeting with the flower show before it starts, and then quite often a meeting after it is finished to try and work out what has worked, what has been less successful and so on. And I mean, that sort of pattern might be quite useful. Now, I appreciate, given the number of events, this might involve more than 2 a year. But if we said, you know, minimum of 2 a year, then we have the flexibility. That would be my proposal.
We need to put into the condition that the offer is made. Because if the residents can't make it, it's not fair to the applicant. It has to be the flexibility that he offers a meeting. We can't assume anything, so that's why we do it.
Thank you very much. That's all the questions I had. Did anybody else want to raise any points regarding the conditions? Thank you.
Do our licensing officers have anything else to add? No?
Not from licensing, no. Thank you.
No? And our governance officers?
Nothing from us. Thank you, Madam Chairman.
Excellent. We've reached the end of this meeting. The committee will now retire to make our decision in private. We will not announce the decision today. Instead, the hearing will be closed. A summary determination will be sent to the parties within 5 working days of today's hearing, and a full decision will follow as soon as possible thereafter. The time limit of appealing the decision will not commence until the full decision has been sent to the parties. I'd like to thank you all. I think it's a wonderful example of collaboration between residents, the council, and the applicant, and I appreciate all your time and sharing with us.
Chair, we appreciate and thank you for yours as well, particularly for listening to me ad nauseum, and also for Colonel Mott for his...
Pleasure. The meeting is now closed.
Very well. Thank you.